Good morning and welcome to the Planning and Placemaking Committee of the 6th of August 2025. I'm Councillor Ian Massey and I'm the convener of this committee. I'll now introduce you to the top table. On my far left is Councillor Grant Stewart, my vice convener, Miss Audrey Brown, Democratic Support Officer, and Mr Jeff Fogg, Legal Manager. And on my right is Mr Christian Smith, Development Management and Building Standards Service Manager. As this is a hybrid meeting, members joining virtually are reminded that if they leave the meeting during consideration of any applications, you are unable to participate or vote on that item when you return to the meeting. This also means that if a member loses their internet connection during the consideration of an item, they should not vote on that item. Please advise the clerk via the meeting chat that you are leaving the meeting, or if you have lost your connection and are therefore unable to vote on that item. And whilst we are operating as a hybrid meeting for proceedings today, can I remind councillors and officers to use the chat box to attract my attention, which all members should have access to. Q for questions, C for comment. I will ask the clerk to confirm any apologies and the attendance of those in the chambers and online.
Thank you, convener. Morning, members. We have no apologies today. We have two members who are online. I'll ask if they can confirm that they are there. We've got Councillor Illingworth.
Present.
And Bailey Williamson.
Yes, present too.
And everybody else is in the chambers.
Thank you. Item 2 is declarations of interest. Do any committee have any declarations of interest? No declarations of interest. So item 3 is the minutes. The minutes of the meeting of the Planning and Placemaking Committee 9th of July 2025. There's a condition contained within the item 532 has not yet been finalised, and the minute will be submitted at the next meeting of the Planning and Placemaking Committee for approval. There are no deputations today, so we move straight on to applications for determination, and this is for a Section 36 consultation. It's installation of battery storage system and solar energy park and associated infrastructure at land 600 metres northwest of Cadam Cottage, Cathwick. And to introduce the report is Mr Smith. Thank you.
Thank you, convener, and good morning, councillors, those in the chamber and all those that are joining us online. This report relates to a consultation issued to the council by the Energy Consents Unit. This in relation to an application for which they are the determining authority. This is not an application which we are here to determine today. Rather, we are here to make comments to the Energy Consents Unit on that application. The proposed development comprises both battery energy storage of 50 megawatts and related solar park or array of 60 megawatt generation, and all that goes with that, all situated to the west of Cooperangus and north east of Burrelton. The proposal itself overlaps with a previously consented solar proposal known as Keithlick. There are other consented and pending solar proposals in the wider locality, and I will show some images indicating those existing approvals or pending applications. The report itself draws together the comments received from Council Services and the Perth and Kinross Heritage Trust, together with an assessment of the planning considerations from the perspective of the Planning Service. The conclusion is that the proposals are compliant with the development plan, and as such it is recommended that the application is not objected to, with conditions on various matters suggested to the Energy Consents Unit. It would then be for the Energy Consents Unit to consider the consultation response in their determination of the application. In relation to those conditions, and as a point to note, condition 12, as set out in the report, should in fact be divided into two parts, one relating to light and the other relating to glint and glare. Presently, the layout of the condition has not been set out correctly, possibly through the formatting of the report and paragraphing, making that error. This will be addressed should the recommendation be agreed. It should also be noted that an objection to the application from the council would trigger a public local inquiry. So I will now take you through a presentation to outline the proposals and to give an indication of the surrounding landscape. This first slide that we have here is an aerial image showing the application site outlined in red. As can be seen, there are various pockets where the energy infrastructure will be concentrated, interlinked with narrower access route. Cooper Angus is highlighted to the east. Next image, please. Here we have a high-level layout showing where various aspects are proposed. The areas of solar shown in blue. A central biodiversity enhancement area is indicated in yellow, with an area below it to remain in agricultural use. The battery energy storage area, or BESS, would be situated in the far right or east, south of the river, and with Cooper Angus of around a kilometre further east. Next slide, please. This plan has been prepared to show the relationship between the approved Ethic solar array and the current proposals, which overlap each other, as set out in paragraph 3 of the report. That overlap is in the centre of the image and identifiable as the area where red and blue merge. Red is the consented Keithic scheme and blue is the proposal which we are considering in terms of our response to the energy consent unit today. Next slide. We now have an image which adds to the previous composite slide by adding in the existing BESS adjacent to the substation to the east of the A94. That is the small area coloured purple above the green. And in addition, that green area is a solar array proposal currently under consideration by Scottish ministers after planning permission was refused by the council, and a subsequent appeal to the Directorate of Planning and Environmental Appeals was called in by ministers. That call-in took place in May of last year, and we are still awaiting a decision from ministers. This grouping of proposals, I hope, gives an indication of the areas south of Cooper Angus which have seen approval or ongoing applications associated to solar and BESS projects. Next slide, please. We now move to a series of images which show some of the infrastructure which is proposed. This first plan, a typical solar panel detail. For information, the height of the panel top edge is circa 3 to 3.3 metres and the lower edge 1 metre above ground level. Panels themselves are set at between 25 and 30 degree angles. Next slide. This is a detail of the inverter containers and transformers, the containers sitting on plinths and the higher of the two reaching a height of around 3.5 metres. Next slide. We then see the smaller substation building, which has a height of around 4 metres. Next slide. I'll now take you through a number of visuals that see images to set some of the context to the surroundings. Firstly, we see the existing BESS, which is adjacent to the Cooper Angus substation. Next slide. This a longer view to the substation itself. Next slide. Here an image much closer. The heights of the substation infrastructure notably significant in relation to the infrastructure elements within the applications. The application itself seeing infrastructure not exceeding 4 metres, which is the substation we saw earlier. So those infrastructure elements comprising mainly solar panels, the small substation, or related to the BESS. Next slide. We then move slightly further from the Cooper Angus substation. Next slide. And there are a number of slides here that I think if we just flick through them, please. These show the areas where the development is proposed, in effect pocket fields with tree belts, hedges and other landscape containment, although topography does vary in some areas such that there are distant views. Convener, that ends the presentation and we will return to the aerial image highlighting the application side. Thank you.
Thank you, Mr. Smith. Can I ask, do committee have any questions for officers? Councillor Waters.
Thank you, convener. One of the real challenges with this is that, you know, the lack of grid connections has meant there's been, you know, a considerable amount of these type of applications coming before Cooper Angus area, and I probably have a few questions on that, but I'll just ask one just now. You brought up the diagram where you showed this application, the red one. Then you had the area with the blue area, which is the ones that's already consented to go ahead, and then the green area, which is the application that's now with the reporter. In relation to the cumulative effect with stuff, and this is, I think, going to be a real challenge for us this morning to get around. So the cumulative effect, and my initial question over that is just over the amount of prime agricultural land that has been lost, the blue application. Determination with this, which doesn't sit with us, but with energy consent unit, what would be the loss with that? And if the appeal, what were successful, what would be the loss of prime agricultural land with that? And it's the real challenge I find reading this paper is how do we judge that level of cumulative potential loss of prime agricultural land and determine what we feel is the right amount, so an acceptable amount to deal with. Thank you.
Thank you. I think there are a number of points there, and I will try my best to break them down into individual elements, but you know, please call me out if I miss anything. First of all, I think, you know, National Planning Policy Framework 4 allows the development of this sort of energy proposal on agricultural land. So there is a question as to whether or not the loss of this land is an issue, or whether that's complying with National Planning Policy Framework 4. So just to put that to you. In terms of cumulative effect, we as officers have taken into account the cumulative impact. As you've seen, we've pulled together a plan that shows some of the proposals within the immediate area. Obviously there are others further afield, and we feel that the impact cumulatively is acceptable, taking into account the various considerations. I think I'd describe it as pocket fields, set out the containment through landscaping, discussed the topography, etc. So the cumulative impact of the proposals that we're looking at is acceptable. I'd probably also say yes, it is currently unknown what the outcome of, I think it's referred to as the Market Hall application, which I would remind the committee was refused at this committee, subsequently appealed. That appeal was called in by ministers. It does not sit with the reporter. The reporter has, I understand, come to a conclusion on that and passed that to ministers, but it sits with ministers. As I said, it's been sitting with ministers since May of last year. We have chased multiple times to get a decision on that, and that has not as yet been forthcoming. The reasoning for that I'm not too sure, but they called it in relation to issues associated to the loss of prime agricultural land, and it would have been very helpful to have had an outcome on that application over the last year and a half. But notwithstanding, we've still taken into account that proposal and feel that the cumulative effects related to the proposals that are subject to this consultation are acceptable, if that answers your questions.
Thank you. Councillor Allen.
Thank you, convener. Thank you, Mr. Smith, for the guidance through that. It's just a furtherance, really. I mean, by and large, Councillor Waters has asked my question, but I'm just going to further it by saying The council does not object, I get that. And now we're talking about a further 260 acres in an area where we've already got another significant piece of land under consideration. And rather than talk about the cumulative effect, I'd just like to understand, the council does not object. What's the ceiling? Where do we feel that the line is that we would say, no, we can't consider that? Thank you.
I think I'd probably refer you to MPF 4 and the relevant policy in relation to soils, etc., which allows for this sort of development on those soils. There is no defined ceiling or area that would need to be considered. You need to look at it on balance, and in this case, the type of development which is proposed is considered by NPF 4 to be acceptable on these agricultural areas.
I was going to say, my response to your question, Councillor Allen, would be essentially it's a judgment call for the decision maker. It's not, as Christian says, defined in the development plan, this amount beyond which you shan't go. So it's left to, in this instance, yourselves, depending on who's taking the decision to decide, is it an excessive scale?
I'm just, in looking at the map and understanding the bits that have previously gone under consideration, it seems to me excessive, and I'm still here to be convinced otherwise. I just feel that if this is all granted and this all goes ahead, we can change the name from Cooper Angus to Solar Angus. Thank you.
Thank you, Councillor Allen. Councillor Allen, I will draw your attention to policy 5, which is on soils in the NPF 4. And B4 is the generation of energy from renewable sources or the extraction of minerals, and there is a secure provision for restoration. These are allowed. These are things that are allowed. So MPF 4 allows for these solar farms, battery energy storage to be done on prime agricultural land. This is what we are working with. Yeah. Bailey McLaren.
Thank you, Convener. So I'm hearing Mr. Smith, and I fully understand the working within the MPF 4 guidelines. However, the frustration is where the recognition of the loss of food producing land, the i.e. prime agricultural land, where there is only 8% in Scotland, is being overlooked within NPF 4. The food supply to food retailers is an important matter, and there is an accumulative impact on that. However, I would like to understand if this land on this occasion that we're speaking about has an impact on the already existing AD anaerobic digester plant that sits within that area, because these photographs that you've shown us were of grass areas, which in my slightly agricultural knowledge suggests to me that that is the food that's going into that AD plant, and there is a loss to an already existing structure, is my question to you. Maybe you don't have that detail.
I think what I would say is that's not a relevant consideration, and I'm sure that the anaerobic digester would ensure that its supply chain was appropriate, and where it gathers its raw materials from is not something we can consider in terms of this application. Whether it even gathers them from these locations, I don't know. That's a matter for that business operator to consider.
Okay, thank you.
Thank you, Councillor James. Oh no.
That fooled you, Convener, didn't it? Here he is, looking online. Thank you, Convener, for allowing me to speak or ask a question. I suppose my question is, like everybody else, has pretty much been asked. However, just for clarity, yeah, we're told about the cumulative impact, and there are some that are outstanding, as you've just said about, did I hear you correctly, Mr. Smith, that one was sent to the reporter and that was made a decision quickly, but it was called in by ministers. So in effect, the reporters made a decision, but it's down to the ministers to say yes or no. Did I hear that right, or have I got the wrong end of the stick?
Yes, that's correct. As I indicated, it was called in spring last year after this committee made a decision. My understanding is that a reporter then drew a conclusion on it, but the matter was called in by Scottish ministers in May of last year, and we are still waiting for the outcome.
Do you happen to know the outcome of the reporter's decision?
No. Only that the reporter has passed their
it's gone
report to ministers.
I mean, I get that, and I guess where I'm going with this, convener, is that the huge worry for pretty much all of us is cumulative impact, and we're told we can use prime agricultural land. What land do we use when there's no tatties left? But the cumulative impact is important, and NPF4, whilst everybody's using it as the Bible, it's guidance. And with people on the ground that know what it's like, it's pointless somebody down the other side of Edinburgh saying what we do and don't need up here in Perthshire. Now, I don't know who upset somebody in Cooper Angus, but if you look at the cumulative impact of these solar panels, the battery storage, it's bigger than Cooper Angus itself. I really feel sorry for these people. So cumulative impact is a massive issue, and I think that we have a right to comment on that, regardless of whether you can build.
Councillor
Yes, you
James,
might
do
be
you have a
able to,
question?
but
You have a question, Councillor James?
okay. Question is, how do you word it? Okay. On a different tack than flooding, I noticed there's no issues with flooding. However, as somebody who used the A984 on pretty much every day to get to work, I remember getting diverted around that road because of flooding, and that cuts through the centre of this site. Why is there no issue with flooding when it's so close to the river?
Thank you, Councillor James. I think I would refer you to the report and paragraphs 66 through 69 that discuss flood risk. There is a flood risk assessment which has been or a flood risk and drainage assessment submitted, and that has been reviewed by our flooding and structures team, who advised of no objection to the way in which the proposal has been laid out. And the risks associated to the infrastructure from flooding. So my understanding is that areas which are at risk of flooding have been avoided, and infrastructure placed in areas where they would not be at risk. I'd maybe try and help you in relation to your previous discussion. And what I would perhaps say, and Jeff may wish to comment on this as well, if we feed back to Scottish Government or the Energy Consents Unit in relation to this application, and this application is determined, then that will be a material consideration in the assessments relative to Market Hill. Although Market Hill may be decided before or after, again, I'd reflect back and say the council said no to that application. There were different factors to consider there, and it was felt that on balance it was not acceptable. So what the position is of Scottish ministers, I don't know. What the position of the reporter was, I don't know. But at the minute it may, well, it would be taken into account the outcome of this application before the Energy Consent Unit, and that may help ministers in their deliberations.
Thank you. Councillor Illingworth.
Thank you, convener. If the committee were to decide to object to this, how would a public inquiry work, and would councillors have the support of the planning team in that public inquiry?
Councillor Illingworth, to an extent, it's down to the reporter appointed in any such inquiry to decide the procedure. But there would be a normal expectation that principal agencies who were opposed to it would be required to attend and speak in support of their objection. And the short answer to your question would be no. Given the professional recommendation of the planning officers was not to object, they would not be participating in the inquiry where there was an objection on behalf of the planning authority at the instance of elected members and not the planning officers. So it would fall to elected members to defend the decision to resist the application.
Supplementary, convener?
Go ahead.
Okay, thank you. Is there a scenario where we go into a public inquiry and have costs, substantial costs, awarded against us?
In any planning inquiry, if it's conducted under the Planning Act, and I'll qualify this by saying, because this is an Energy Act 1989, it might not apply. So I'm not 100% sure, but ordinarily the expectation is that each party bears their own costs in inquiry, and that's not a liability of the other side. There is an exception to that where the reporter is satisfied that the actings of a party have been unreasonable and that unreasonable conduct has caused unnecessary expense. Then a party who feels they've been put in that position can claim expenses from the other side. So in some instances it's possible to make a claim for expenses and have that awarded. That then means that a party in that situation bears not only their own costs but the costs of the other side claiming expenses from them.
And those, if that scenario were to happen, the expenses would be borne by the council, not individual councillors.
Yes. The scenario of surcharges on individual councils ended in the early 80s, I think. So yes, that is no longer a possibility.
Okay. Great, thank you.
Thank you, Councillor Illingworth. Councillor James, you want a point of clarity?
Yes, please. I thought that we were just consultees in this, so we're just being asked a decision. You know, what was our thoughts on this? It's out of our hands, so surely we wouldn't be liable for having an opinion. You are asking me to speculate. Say the normal expectation is the parties participating in inquiry bear their own expense of that undertaking. It's only where the reporter accepts that one party against whom a claim for expenses is made has acted unreasonably, can he or she then award expenses against them. So normally, providing it's within reasonable parameters and not in bad faith and not, then there shouldn't be an award of expenses. You're allowed to take an opposing view. It's not unreasonable to have a view that ultimately isn't accepted by the reporter. That's not unreasonable conduct. If it's an application that's previously been considered by a reporter on appeal, being granted, and then it comes in again in identical terms, and you again try to refuse it without any good grounds, that's shifting away from the normal reasonable behaviour to unreasonable behaviour. So ordinarily, a decision taken in good faith should not be the basis of an award of expenses. But as I said, nonetheless, there can be considerable expenses just for participating in the inquiry itself for your own side.
Thank you. Councillor Waters.
Thank you, convener. If scenario here. If we're, I think there is a general concern about the cumulative effect with all the applications together. Is there a way? If this committee was still minded to does not object to this application, is there a way still to convey to the Energy Consent Unit our concern as a committee, and certainly my concern individually over the cumulative effect or the potential cumulative effect of the amount of land around Cooperangus, prime agricultural land, and its impact on food security, etc. Is there a way that that can be achieved within the powers that we have as a statutory consultee? Thank you.
My view to that one is that it would be open to the committee not to object to this application and take that as its position, but nonetheless intimate to the Energy Consent Unit that the committee have concern about, whilst not having objected, it does have a concern about the potential loss of agricultural land and industrialisation of rural land in the Cooperangus area should all applications in that vicinity come forward. And you could just do that in a general sense. Yes.
Thank you. That's helpful.
Thank you for all those questions. Do we have any further questions? No further questions. Can I ask for a motion? Councillor Braun.
Yep, thanks, convener. I'm going to move that we formally object to this proposal. If I may first of all be clear that the principle of solar farms and wind turbines, or windmills as one particular politician calls them, I don't necessarily object to them. I've said in the past planning committees that when these are installed, after a short period of time, they become part of the landscape. We had a photograph on earlier with a substation with a pylon, and I would think everybody would agree today that when you drive past pylons across fields, nobody even bothers about them. They're just part of the landscape, as do become wind turbines. But the important thing is that they have to be in the right place. And I feel that over the past few months, we're slowly seeing potentially Cooperangus becoming some form of industrialised site for solar farms. And in doing so, we're losing prime agricultural land. Now, our own policy 50 says that prime agricultural land should be protected. And it does allow for essential infrastructure. I would argue that at the moment, this is not essential. And I think that the cost of losing prime agricultural land in this instance, and what we've seen and what we've already approved, is getting to the point of too much. We talk about MPF4, and I agree it's there. It's a national policy. It wasn't our policy, it's a national policy. But I don't believe that when the various parties, Scottish Government and whoever, drafted MPF4, they believed that it would be turned into this and that prime agricultural land would be thrown at solar farm developers just like this. That wasn't the spirit of what MPF4 is about. It's about producing renewable energy in the right place, the right time, whether it be wind turbines or solar farms. That's what it was for. And I feel this is now, we're witnessing the abuse of MPF4 simply by people throwing prime agricultural land out to do this. So my motion coming down to say I'm not against these things in principle, it's just this is not the right place. And I appreciate this will not reject the application, merely put us into a public inquiry, which I think is deserved in this instance and in this area. I think it'll be a good thing for everybody, whatever the outcome is, people get their chance to speak. So my proposal is that it contravenes policy 50 of our own LDP2, that the need for this is not essential at this time, bear in mind what else is happening. And I would argue also, given the size of this development, 104.6 hectares, that it will industrialise this part of the area, and I would therefore say it contravenes policy 1A and potentially parts of policy 1B. I don't have my book with me, so I can't give the subsections, but I think C is to do with density, but we can finalise that. But that would be my proposal, that we move formal objection that it contravenes policy 50. It's not in the spirit of MPF 4 and also contravenes policy 1A and 1B, and there's certain subsections within that. Not sure if I'll have a seconder for that, but that's my motion. Thank you.
Okay, thank you. Councillor Waters, you have a point of clarity.
Just if appropriate, to come in at this point and ask for it, and it's not about the motion in a sense. From so you mentioned that there would be a public local inquiry. Does that, and it's just my understanding of what that means, does that mean that this would automatically go to a public inquiry or a local inquiry? Because my understanding is they're both different. Or is it a public inquiry? This goes to just the actual confirmation of the actual process and what's.
I don't see there's a material difference between the two, Councillor Waters. It's a public inquiry, a local.
Councillor Harvey.
Yeah, I just wanted to ask for some clarity regarding the motion from, I think it was Councillor James. The conversation there kind of regarded the kind of cumulative effect, which I understand the concern, but are we not just addressing this development here? So how much of that can we take into account in that kind of motion? I just want clarity from the officers. Thanks.
Well, from my point of view, officers take in the cumulative effect of everything that's going on in that area. So there is no reason why we can't take in the cumulative effect of everything that's going on in that area.
If I may, convener, I don't disagree with the position the convener's taking. The difficulty you all have today is the uncertainty as to the status of the Market Hill site, which is 90 hectares, which is a very substantial size, almost equal to the 106 hectares that this is, and we don't know whether it's going to be consented or not, which makes it much harder because you're being asked to determine this without that knowledge. So I think you're allowed to, perhaps on the precaution principle, presume the worst case outcome.
Okay, thanks.
Okay, thank you. Councillor James, you wish to second?
Thank you, convener. And yes, Mr. Fogg has just made the point that I was going to make. I think we don't have all the information available to us, today, and I think the public have a right to have their say in this. This is a massive cumulative impact. There are other factors that I'm not overly happy with. The flooding, as I've already mentioned, I've drive this site regularly. But very happy to second what Councillor Braun has already said. Thank you, convener.
Okay, Mr. Fogg, do you wish to?
Yes, convener, can I just clarify first with Councillor Braun, because I didn't hear you say it expressly, but is part of your reason for objecting to this based on the possibility of the Market Hill site also coming forward?
I think it's a possibility, but I think even if that didn't go ahead, this is a sizable development, and I think it needs to be assessed under public inquiry. I think because we've already approved other sites here already, which has cost prime agricultural land. So I think, as I said, I don't think this is not the spirit of what MPF4 even started to believe in, I think.
while we're looking, Councillor Braun, I think one point I should point out is that the advice of the Scottish Government was that both NPF4 and local development plans were to be interpreted as aligned insofar as possible, but to the extent that there was a conflict between the two, priority should be given to the latest document. And in our case, because LTP2 is a 2019 document and NPF4 was February 2023, to the extent there's a conflict, NPF4 would be expected to prevail. So one would not ordinarily expect policy 50 of LDP2, which is on renewables, to prevail over the most current iteration of NPF4, and that would be a problem. And I would expect the reporter looking at inquiry to be approaching it from that standpoint.
Switch. Councillor Braun, do you wish to have a 5-minute recess?
I think we should have a recess.
Thank you.
To go through this. If you
We'll
don't mind.
take a 5-minute recess. Thank you. Okay, thank you. Welcome back. Councillor Braun.
Thanks, convener, and also my thanks to you and Mr. Fogg for giving a few minutes to discuss this. Following the discussion and on reflection, I feel I still a motion to object, formally object, but now I think the given the situation with policy 50 and NPF4, I'm suggesting therefore that we move to object based on NPF4 policy 4. And also our two background policies of our own, that's policy 1A and policy 1B section C. Given the massive scale of this development and potential industrialisation of the area, I feel that a public inquiry will be a way forward. If I may just add one final point, I mentioned that in my opinion there's been some abuse of NPF4. Can I make it clear that abuse is not the officers? That's my opinion of developers, it's not the officers abusing it. Thank you. So I was just saying that in my original piece, I mentioned that the NPF4 was being abused. I wanted to make clear that wasn't the officers making that abuse. Thank you.
Okay, Councillor James, are you happy with that?
I'm more than happy with that. Thank you, convener. Thanks for giving us the time.
Thank you. Mr. Fogg? Just a second. Councillor Harvey?
Sorry to jump in. Sorry, I'm not as aware of the policies as some others here. Policy 4 refers to what? Could you just give me the background? Thanks.
Yeah, I'll read it out. Maybe if it helps. Councillor Harvey, policy 4 is found within the subheading of natural places of NPF4. And after providing instructions in relation to the drafting of local development plans, it goes on to say in paragraph A, development proposals which by virtue of type, location or scale will have an unacceptable impact on the natural environment will not be supported. And it then goes on to deal with other things in relation to areas of special conservation and Ramsar sites and so forth. So it's in very general broad terms.
Okay, folks, can I ask, is there an amendment? Councillor Harvey.
Yeah, thanks, convener. My amendment would be to accept the findings of the report. I accept there's some concern, as in the previous meeting, over cumulative actions. But as far as I'm concerned, this development meets all the requirements of the legislation. And the motion appears to attempt to question the application of various NFPA and LDP related actions. I think there is important issues regarding food security and land use. However, they're not specifically part of the legislation to be addressed here, and I think we have to be careful in a legal matter. So therefore, I'm moving the amendment to accept the findings as per.
Thank you for that. Do you have a seconder? Do you have a seconder for the amendment? Councillor Waters.
Thank you. And it's just on the proviso, if Ken is happy with it, there's a strong message within accepting the officer's recommendation for this, that given Market Hill and given the other applications, that a thorough look is a thorough investigation is done into the cumulative impact of the loss of prime agricultural land. I'm a wee bit concerned about the natural places, because I just have a look at that policy 4, and it seems to be about nature. And I'm not sure how that fits in with the prime, because so the main concern is that I have is the loss of the cumulative loss of prime agricultural land throughout around Cooper Angus and across Perthshire and Kinrossshire, and that has to be looked at a cumulative level. We don't seem to be able to give that. I think the diligence that's required for the severity of this type of an application, and given that we are just consultees within this, we have to trust in the process to ensure that the energy consent unit will do a full cumulative look at the agricultural prime agricultural land that would be lost. And this is a big part if all the applications were to come into effect, and that includes the industrialisation of the land around Cooper Angus as well. So I think it's absolutely imperative that, you know, whatever we were minded to do, whether we're going to go for the natural land element, or we're going to just as a consultee try and raise our real concerns over this cumulative element. So if Ken's happy to accept that, I'm happy to second the amendment.
Thank you, Councillor Harvey. You happy to accept that into your amendment?
Yeah, I'm happy to accept that.
Okay, thank you. Can I ask members if they have any comments on the report? No comments. Okay, right. Councillor Harvey, do you wish to sum up?
Always forget. Thank you, convener. Always forget. Yeah, I don't think to add any more to what I said earlier. Quite happy to accept this recommendation, because I don't think we should be out interpreting ourselves what NFPA4 and LDP means. Thanks.
Thank you. Councillor Braun, do you wish to sum up?
No, thanks, convener. I think I've said enough.
Thank you. I'll now hand over to Mr. Fogg. Thank you.
Convener, the motion of Councillor Braun, seconded by Councillor James, is to lodge an objection to the application on the basis that the proposal is in contravention of policy 4 of MPF 4 and also background policies 1 and 1AB, 1BC of LTP2 of 2019. The amendment by Councillor Harvey is to accept the recommendation in the report of handling, but to, in responding to the energy consent unit, express some wider concerns about the cumulative impact and the loss of agricultural land if the various developments in this area are to be proceeded with, and the industrialisation and the effect of that on the settlement of Cooper Angus. So I'll pass you over to my colleague, Ms Brown, who will take the roll call vote.
Thank you. In terms of Standing Order 21.5, we will now take a roll call vote when I call your name out. If you can advise whether you're voting for the motion by Councillors Braun and James where they object, or the amendment by Councillors Harvey and Waters to go with the recommendations within the report. Councillor Allen.
Motion.
Councillor Braun.
Motion.
Councillor Cuthbert.
Motion.
Councillor Harvey.
Amendment.
Councillor Illingworth.
Motion.
Councillor James.
Motion.
Councillor Massey.
Amendment.
Bailey McLaren.
Motion.
Councillor Stewart.
Motion.
Councillor Waters.
Amendment.
Bailey Williamson.
Amendment.
We have 7 votes for the motion and 4 votes for the amendment. Therefore, the motion will carry.
Thank you for that. Therefore, that means that the consultation goes forward with an objection from Perth and Kinross Council. Thank you. Move swiftly on to the next item, which is item 6, which is a plan, and it's for a mixed-use development comprising erection of a hotel, restaurant, two drive-through restaurants, petrol filling station with an auxiliary retail unit and EV charging facilities, formation of HEV overnight parking with associated welfare building, installation of solar array up to 2 megawatt with battery energy storage and CHP, formation of access road and vehicle parking, SUDS landscaping and associated works, land 200 metres west of Horn Farm Cottage at Errol. Can I ask members if they have any comments on the report? No comments on the report. Oh, Councillor James.
Sorry, convener, I couldn't. It wouldn't allow me to put a C in my computer. It's nice to see something like this actually coming forward, to be honest. But what I would say, bearing in mind the conversation we've just had about land use and solar panels, if there's any way of incorporating the solar energy element of this into the roofing of the buildings, as in the canopy for the garage, for instance, so much roof space where a lot of these energy projects could be put. It'd be nice if that was included, or given us an option. Thank you.
Thank you. Any further comment? Further comment? Okay, there is no further business today, so thank you very much for your attendance and have a nice day. Thank you.